Oh, thank you. And he is with, the law firm Tarzwell and Trubiano in, South County, in South Kingstown. So we're passing out agendas right now. It is meant to be a discussion, so if you have questions along the way, please feel free to ask. You're welcome.
Great, thank you. Thank you very much. I appreciate the invitation to speak to you all this evening. My office, we concentrate our practice on estate planning in general, special needs planning in particular, and all aspects of probate law, which include guardianships. And I'm so here to speak to you guys a little bit today. I guess I had sort of 4 general topics on the agenda. The first would be guardianships and alternatives to guardianship. The second would be just some estate planning basics, talk about what happens at death and how to deal with transitioning assets. The third idea would be to talk a little bit about some common means-tested benefits that many individuals with disabilities often use, and how the inheritances and other transfers of assets can affect means-tested benefits. And then finally, just to wrap up with special needs planning options. So what do you do if you have a family member who has a disability and is on mean-tested benefits? How do you avoid problems with their benefits when you're dealing with an inheritance or a loss in a family? So to start off, I assume all of you or most of you are here because you have a loved one who is perhaps about to turn 18 or will be in the future, and they have special needs. And so you may be wondering, what do you do when a child turns 18? When that happens, by default, everybody becomes an adult. And so while parents are the natural guardians of their minor children, which means you are already, in effect, guardians without a court appointment, in order to retain that same authority and decision-making power, there are really 2 main vehicles to do that. The classic one that everybody knows is guardianship, but today it's sort of seen as a last resort. So it's very useful and very effective if someone has the right circumstances, but we typically try to explore alternatives to guardianship before we would petition for a guardianship. And that is because a guardianship takes away a person's rights and vests them in the guardian, not unlike a parent-child relationship. But for a lot of adults who are very high functioning, that might be unnecessary. You want people to be as independent as possible. And so taking away their legal rights to transact and make decisions it may be just too much. And especially for folks who can get by, who have good supports, some of the alternatives to guardianships are more appealing. Frankly, they're cheaper as well, and they provide a lot more flexibility. So if you fit that mold, the first thing that we would explore with any client would be powers of attorney. Any adult can appoint another person to act for them, to do things, enter into legal transactions for them. Okay. The benefits of using a power of attorney, unlike a guardianship, instead of taking away somebody's rights, you are simply sharing that person's rights. So if I were to appoint someone as my power of attorney, they would be my agent, and I can still exercise all of my legal rights, but they can exercise my legal rights as I authorize. I would still be the boss in that relationship. Sometimes the person who signs the power of attorney or who gives the power is called the principal, and the person who's acting is called the agent. So the principal always stays in charge. Sometimes that can be problematic, but for many cases, an adult child has a good rapport with their parents. They get along well. There's not a lot of strong disagreements about major life decisions, in which case POAs are a great option. The powers of attorney that we typically employ are 3. One is for healthcare, one is for property, and one of them is sort of a creation of the state of Rhode Island and the Department of Health, which is a power of attorney for what's called advocacy. And I'll just sort of tackle each one in turn. The healthcare POA, Many of you may be familiar with these already. Sometimes they're called health proxies. The idea is you can appoint up to 3 people to make healthcare decisions for you. They only take effect when the patient's treating doctor or medical provider, in their professional judgment, thinks that the patient can't give informed consent. And that can be for any reason. It can be because of a disability, but it can be because of anesthesia. It can be because you're, presently unconscious, having an episode, whatever it may be. So it could be a temporary circumstance or a more permanent one. And once the medical provider has made that determination that the patient can't consent, the health proxy steps up, or the healthcare agent, they're the same thing, and will make those decisions, can consent to medical procedures. Typically, there is one person in charge, and then you name up to 2 alternates. So if your primary health agent cannot, is not available, or for whatever reason cannot act, you have backup people who can step up and do the job. The second power of attorney is a property power. So that's going to be all your legal rights that aren't health related. So we're talking about banking transactions, interacting with the government, interacting with benefit offices, exercising all of your civil rights. So the right to sue and be sued, defend a lawsuit, file taxes, claim insurance, whatever you can think of under the sun that isn't a health decision would be covered under a property power, or a properly drafted property power of attorney. And then finally, the third one would be an advocacy power. And again, that's a creation of our state laws. And it essentially doesn't give the agent any particular ability to act, but you can name people who have the right to effectively receive information from the state on your behalf. And the way that this typically works in practice is you can name people who could go with you to a government office, including a school, for example, sit with you at a meeting, and they wouldn't be frozen out because of confidentiality or other privacy restrictions. And so that person isn't there to act for the individual, the principal, presumably the person with the disability, but just to help, to be a helper, to help understand what's going on and help that person, help their principal make the best choices that they can make. So that last one is more of a convenience. There isn't really anything that an advocate agent can do that a property power agent can't do. So the property power is usually reserved for parents and immediate family, that as the case may be, whereas the advocacy, we typically would include either more extended family members or friends, anyone that the person would rely on to commonly go run errands, right? It could be any trusted person that could go attend a meeting if you need an ID card, someone who can go to the DMV and wait in line with you and help you fill out forms, or that sort of thing. And with those 3 documents combined, the people named in those documents can do all of the same things that a guardian can do. So there isn't, from a power perspective, there isn't really a difference. It's not like there are certain things that a guardian can do that a POA can't. The only real difference between the 2 is that under a power of attorney situation, the principal can fire the agent. Okay, they're in charge, so they also have the power to revoke and appoint some other agent, right? For some folks, that is a problem. For many, it is not. And sometimes we have cases where it starts out as not a problem, but it can become one. If and when that happens, typically a guardianship would then be sought. Whereas with a guardianship, the principal, there is no principal. The person who's under a guardianship is often called the ward, and the ward is not in charge. They certainly have rights, but everything has to go through either the guardian in the first instance or the court ultimately. So if there is a disagreement between the ward and the guardian, the ward or the guardian or both, or any interested person, can petition the probate court or any other court that might have jurisdiction to break the dispute. And in most cases, that's the probate court.
Isn't it more difficult to get guardianship after you have a POA, like if they're older?
So it's not, well, no, actually, in order to get a guardianship, one of the legal requirements is to demonstrate either that you tried POAs and they didn't work, or give a good reason why you didn't need to try them in the first place. So the courts don't want to just rush people into guardianships anymore. I know, some years ago, it was sort of just the standard procedure is people went right into guardianship. But now the Rhode Island laws actually require that that the petitioning party has either explored lesser restrictive alternatives or, has done them, but they just failed, right? And so, no, it doesn't make it harder. In fact, if you have a POA and it's not working because the principal is not agreeable or whatever, oftentimes that is the prerequisite to get into court and get the guardianship. If anything, it's easier at that point because you can say, hey, judge, we tried to use a lesser restrictive alternative. It's not working because of the dispute. So that's essentially how that goes down. But it can be very, like I said, a guardianship. They cost thousands of dollars to create, and they are not impossible to undo. But again, it's a similar procedure. You have to go and file a petition with oftentimes medical evidence to convince the court that it's no longer necessary. And while the courts aren't going to keep a guardianship in place where there is no need, you're still talking about a substantial legal process. Whereas powers of attorney you're talking about hundreds of dollars, not thousands, and it's a one-time transaction for most people. You set them, you name the people who will act, and perhaps some backups that are contemplated in case your agents, for whatever reason, can no longer act, and they may last a lifetime, or even if they only last a decade, that's still you're getting a lot more sort of value for your dollar. Not to mention that the individual, the principal that we're talking about, will retain their rights, so they can still go and transact. I mean, technically, when you're under a guardianship, if it's a total guardianship and it covers finances, you're not supposed to even. I mean, technically, you're not allowed to buy a stick of gum without your guardian's approval. Now, as a matter of practice, it's not that strict, but a guardian really does have an awesome power that has been taken away from the ward. And so again, sometimes that's totally necessary and we do it. But I encourage everyone to explore the powers of attorney first. Now, you may be wondering, well, what does it take? How do you know if powers of attorney are applicable? And actually, fortunately, the standards for creating a POA are pretty low, and it doesn't matter whether you have a disability or not. I mean, I'm of the view that every adult should have a power of attorney, because you never know when you may not be able to make your own choices, or just it might be inconvenient to do so. You might be traveling and stuck abroad for some reason, and if you have a POA, that person can pay your bills or send you money or talk to the government on your behalf. Whatever you need done, that person can do. So the standard is just the ability to express to the attorney who's preparing the documents that the principal trusts the agent effectively to make choices for them, to make legal choices for them. So as long as you can express confidence in another person to act for you, as long as the attorneys are satisfied that is, the person comprehends that this will continue something like a parent-child relationship, even though the principal remains in charge, unlike in a parent-child relationship, then you can do a POA. And as an example, I like to give, my grandmother, who is no longer with us, but when she came to this country years and years ago from Italy, she didn't speak any English. She had a very rudimentary education. She didn't understand the documents that she was given for taxes or whatever. I mean, she always did what she needed to do, but ultimately she appointed her sons when they were of age to be her POAs. She probably couldn't tell you what was written on the document. If you explained it to her, she might understand the gist of it and okay, yeah, I want my son to act for me, to make these choices for me. But that you don't have to know any of the legal jargon or know what a capital gains tax is or whatever the issue may be. As long as you understand, I want this person to be in charge of my medicine, my health decisions, my money, whatever. If you can express that competently to an attorney, then more likely than not, you will be able to execute a POA. And that will alleviate a lot of stress on families where that's applicable, because they don't have to go and pursue a guardianship. If for whatever reason that situation is not available, if the person is not high functioning enough to even be able to communicate that in a credible way, if the professional involved has some doubts, then at that point the issue may be a guardianship. And you would explore that at that time. Any questions so far? Sure.
Both power of attorney and guardianship, what if the family relocates to a different state?
So for POAs, because of the Constitution that has a clause called full faith and credit, documents that are legally valid in one state technically have to be honored in other states. My recommendation, however, is if you're going to move and you have POAs, and again, whether you are disabled or not, it's usually a good idea to have a new one created in the home state where you're going. Only because every state's forms are going to look a little bit different and every state's laws might be a little bit different. So for example, there might be certain things that a health power can do in one state that they can't do in another. And so the documents should usually reflect whatever the accurate law is. Is it a deal breaker? No. And if the principal can't sign anymore, use the one that you have. It should be good. If people reject it, if a bank or a hospital, someone refuses to honor it, then you will have to, consider whether you want to fight about it in court or just sign a new one, or depending on the reason why it was rejected, maybe go get a guardianship. And then as far as guardianships are concerned, if you're going to transfer a guardianship to another state, yes, you have to shut down the guardianship in the home state where it was created and then transfer it over to the new state. Most states have adopted a uniform law on that. So the process is uniform in all but I think 2 or 3 states. Florida is one of the states where they don't use the uniform law, and in a weird way, it's easier and cheaper to go to Florida, but it's not that different. But in theory, and I've seen this before, actually in practice, if there's an active guardianship in Rhode Island, people can move to Florida and start a totally new guardianship without letting Rhode Island know, without shutting down the Rhode Island one. But the guardian that was appointed in Rhode Island remains sort of subject to the Rhode Island courts and their jurisdiction. So sooner or later, the Rhode Island courts will get wind that the move has occurred. And if no action is taken, the court will be calling that guardian in to say, all right, look, you have to do a final accounting, wrap things up. Why aren't you here anymore? And it'll be taken care of. But in both circumstances, moving is not a problem. It's certainly easier with powers of attorney, but it's not a problem in either camp.
What's your opinion about doing this for kids that go off to college? They're getting out there.
Yeah, I would defer back to my original comment that I think every single adult should absolutely have POAs as long as there are people that they trust in their life to make choices. So yeah, I made my all my family members do that especially when they go to college. It's a great time. Yes, because you never know when you're going to be needed to come in and solve a problem. And if you have POA, it makes things so much easier than if you don't. Because again, once any child turns 18, as the parent has no legal authority over them, even if you might be the person who's financially choosing to be, paying for them and solving their problems, right? But it is a good idea. Absolutely.
So they can't execute a POA until they're a majority.
Correct. And a lot of
a guardianship, which you actually might consider starting before the 18th birthday.
No, you would never. So there's no need to start a guardianship before 18 because the parents are already guardians.
Well, I didn't know if a month, you said it's a legal process. I'm sure there's some time involved.
So you can start the petitioning before.
Okay.
Yeah. So you can try to time it so that the guardianship is granted either on the birthday or within a short amount of time of the birthday. Absolutely. The POAs, again, we would get the process started in the days or weeks prior to the 18th birthday. And then as soon as people want to come in and sign, they just come in and sign. I have a lot of people coming in on their 18th birthday, on their way to the birthday party, signing the POAs.
Go to the post office, go to the watch.
Right. Register the boys, register for the draft or the selective service, whatever they call it. Register to vote, that sort of thing. But yeah.
How much earlier should you start the petition for guardianship?
So guardianships, yeah, that's a great question. In Rhode Island, you have to, there's a couple of things that you need to create a guardianship. The first thing is you have to get the primary care doctor, or if there is no primary care doctor, it has to be another treating doctor. And when I say doctor, it has to be an MD or a DO. to fill out a form called the decision-making assessment tool. A lot of times you'll hear it referred to by its acronym, the DMAT. So you get that done, and then once the DMAT is completed, an attorney can prepare the actual petition and related documents. Those things would then need to be filed with the court and advertised. And usually, once you file, you will get into court about a month later. Sometimes it's a little sooner, but usually, depending on what town you live in, it's about a month. So I would suggest guardianship process, you should be in touch with an attorney 4 to 6 months before the 18th birthday at the latest. You don't have to go too much further beyond that because DMATs expire. So I wouldn't recommend someone who just turned 17. You know, if you have a child who just turned 17, don't run out and get a DMAT because by the time they're 18, it's no good. And me or any lawyer like me is going to say, go get another one because the courts will not accept them. A DMAT, because it's a document that medically certifies that a person has a need for a substitute decision maker, the courts want to make sure that they are up to date and there's been no change in circumstances. And so they have a very short shelf life. So the best ones are done within a couple of months of the petition being filed.
Okay, you should call the town hall in Smithfield and find out, they don't always, every time they meet, they don't always discuss guardianship. So you have to find out which one would be the closest to your son or daughter's birthday.
I've never had that be an issue. If the courts are going to hear a guardianship, I've never heard of a session that would restrict and say yeah, there will be a general session for sure every month and
But they've always discussed guardianship. I know that for a fact. I know parents in this town that have had problems.
yeah. So again, Rhode Island is a funny creature. We have our probate courts are town run. And so every town has their own court with their own judge and their own rules, and it's not part of the state system. Having said that, and again, this is just from my experience, I've never had an issue where the court would refuse to hear one if there's a need. And in fact, even though probate courts typically meet once a month, in the larger cities and towns, they meet more than, Providence will meet weekly, I think. But most of the cities and towns that are smaller, the towns anyway, they meet once a month and they will have what's called a general session where all matters can be heard. I suppose a really small town might be restrictive, but again, I've never had that be a problem, especially if there's an urgency, and anyone can request the judge to give them what's called a special session. So if you really have a need, that option is available. So I would be very skeptical that you couldn't get it done if you needed to. There would be a way. Again, it may take some more doing and it may be a little bit inconvenient, but there would be a way. There's always going to be a remedy. If there's not a particular urgency, it might not be a factor, but my practice is to typically get these things filed, and it is possible to file them and have them heard before the 18th birthday, with the understanding that the judge will grant them as of the 18th birthday. So if the circumstances warrant, you can get in ahead of time and say, all right, we're going to grant it in January, even though the person doesn't turn 18 until February, but it won't be effective until the 18th birthday. It's our preference to not do that wherever it's possible, because again, the courts, they want some justification as to why we're sort of doing something a little bit prematurely, but they have the discretion to do that. So again, as long as you're in touch, I wouldn't recommend doing it yourself. It's not that it's impossible, but there are a lot of rules and restrictions. And if you sort of make a mistake, it can be an expensive fix. One thing that I can sort of tell everybody is there are also different flavors of guardianship. So Rhode Island, we colloquially sort of refer to a full guardianship, a guardianship that expands over all decision-making matters, we call that a full guardianship, even though the law doesn't use that term. And it encompasses health decisions, financial decisions of all types, residence, where you live, and associations, who you can interact with. And when those guardianships are granted, as a weird byproduct of our state constitution, it will automatically void an individual's right to vote. So my practice is to always go in and ask the court to do a limited guardianship instead, And in some cases, the only limitation is we're not taking away this individual's right to vote. If you're not pursuing a full guardianship, the limited guardianships run the range from everything but the right to vote is under guardianship to very, very limited to just specific purposes. So you can tailor make a guardianship and say, this person can act on their own in all areas except these particular circumstances, in which case we can appoint a limited guardian who only has power to, for example, make health decisions, or, maybe only make health decisions for, let's say, complicated matters like surgery, but not for routine things like a physical. So you can tailor make a guardianship as the need arises. But in any respect, if the person is at all capable of voting, even if they have no interest in it, I always will preserve that right to vote. And that's something that most people you wouldn't pick up on that, because it's not in the statute, it's not in the laws, it's part of our Constitution that says if you've been declared totally incompetent, then you forfeit the right to vote. I think that stinks, but until they amend the Constitution, our workaround is we just ask the court to carve it out. But we can also make other carve outs to everybody's individual circumstances. Similarly, there is another procedure called a temporary guardianship, which is available when people just need to, again, run into court on an emergency basis, usually. You can't do a temporary guardianship without also petitioning for some type of permanent one, whether it's limited or unlimited, but you will get into court faster and sooner. Sometimes you don't have the DMAT yet, but it's coming. You can still get a temporary guardianship, and that's great for a specific transaction. So I had a number of cases where the person in question needed to have surgery done, and the time it was going to take to get before the court on the permanent guardianship was just a little too long. We could run in on a temporary earlier, get it done, give the consents that were needed, and then at a more convenient time, have the full hearing. Other times it's useful to make military elections. So people who are going to get a military pension, perhaps from a deceased parent, the individual technically has to make an election about what they want from that pension. And if the individual has no competency to do that, a guardianship is required. And so sometimes a temporary coupled with a limited can meet that need. Other questions so far? That's okay. I'll just.
Are you appointing one guardian, or like when you go, have more than one?
The petition has to specify who wants to do the job, or who is seeking to be appointed. It can be it could be more than one. So typically if there's, mom and dad, then yeah, we will do co. If sometimes we will add a guardian, if let's say someone only has one guardian, sometimes we will add a co at some point if the current guardian is thinking of resigning, maybe either due to age or infirmity. Sometimes if even in a tragic scenario where the current guardian has a terminal illness or something, we can sometimes get a new one in to make it more seamless, so there's no interruption, even if you don't catch it. But no, it's very customizable as long as the person is suitable. So the decision about who gets to be guardian is ultimately with the probate court or the superior court, but for our purposes, everyone starts in probate court. And the legal standard is just you have to be suitable. And you can say, well, what does that mean? Well, it means if you've committed certain crimes, you might be ineligible. If you have very obvious difficulties performing ordinary, responsible life activities, people who have substance abuse issues may be excluded. People who are just generally not, sort of ordinarily responsible. It doesn't require any kind of superhuman qualification, but if you're, if a person can't manage their own affairs, they may not be appointed as guardian. But outside of that pretty low bar, not certain felonies are not okay. Substance abuse and someone otherwise just being unable to conduct their own affairs, as long as there's no objections, you're going to likely be appointed. Having said that, sometimes families fight and they'll object to who.
Like, yeah, like what,
The court will require a BCI background check, and it's a national check now, not a statewide one like it used to be in the past. So whoever is seeking to be appointed guardian will have to have that cleared. There's also, the court will appoint another lawyer called a guardian ad litem, and that person is there to interview both the prospective ward, but also the prospective guardians to just get a sense of who they are and write a recommendation. And so if the GAL does an interview and they think that the guardians aren't suitable, they'll put that in the report. It doesn't mean you won't get it. It just means that your lawyer is going to have to convince the judge that the GAL was wrong, or, do something to assure the courts that whatever the issues are won't be a problem. But the courts are going to be first and foremost concerned with the ward's well-being. Not, they're never done for the guardian's convenience.
I just want to make sure you're not coercing your son or daughter into.
Correct. You're gonna find that every part of the guardianship process is meant to weed out people who any ordinary person would say that should never be, that person should never be appointed. So, good ordinary folks are not gonna have a hard time, but you will have to go through the same hoops, make sure that you're not a felon, a drug addict, taking advantage of the ward, trying to steal their money, whatever the case may be. Makes sense? So I would encourage everyone to, certainly if you have any other questions, you can ask me at any time. All my contact information is on the handout, and we have some business cards, so you can always reach out to our office. So we do that kind of work. And again, our first task is to see if POAs are going to work for people and avoid the need for an expensive guardianship. And unless there's any other questions at the moment, I'll just continue to some of the other alternatives.
So I guess we already had one issue kind of along this line where, money was kind of spent foolishly. On an internet purchase, and I guess that might be, that's something obviously under the power of attorney that would still be available to do that, right? I mean, that won't prevent that, I guess is the question. So, yeah, I mean, when it comes to prevention, even a guardianship isn't going to prevent someone from clicking on a mouse, right? True. So, the legalities of it are another story, but typically speaking, whether you're a court-appointed guardian or you're just someone appointed you their agent, to stop that person from making foolish choices is going to be a non-legal problem. That's going to be a family supports issue, right? So whether access to the computer is the bigger problem, setting some parental settings on the computer, anyone can do that. But that's not something that is efficiently resolved in courts. You're going to find that a lot of the sort of day-to-day problems that you may have, certainly the POA can call up the internet service provider or the company on the other end and explain the situation and say, hey, this purchase was made by someone who, is not competent. I guess I was more concerned about at 18, obviously you could do more damage more quickly at 18 when they start sending you credit card offers. That was the kind of thing, I guess I was thinking along that line.
Yeah, I mean, well, credit card offers though are not, if someone has the wherewithal to apply for a credit card and get it, good on them, but it's not like they're automatically granted. And again, if the person lacks competency, a good agent is going to intervene at some point and let the credit card company know, or whatever. So what it does give you, whether you're a POA or a guardian, is you have the standing to be able to contact the other party in that transaction and let them know what's going on and that they should be interacting with you for going forward. And and you're going to find that most entities, any reputable entity certainly, is not going to want to force a fight on that. Imagine just the bad press, a person who's disabled runs up a big bill online or whatever. That company doesn't want the black eye of, call Channel 12 or something like that.
But in either case, you have the ability to advocate for that and basically make that threat.
Yeah. In my experience, it almost never comes to threats. It's just a matter of spending the time to educate the people on the other end about what happened. And it's not necessarily easy, but I wouldn't just assume that a guardian is going to have an easier time than a POA. In both cases, it's the same thing. You're going to just convince the other side that, hey, this shouldn't happen. If they're very stubborn, okay, both parties can run into court. The guardian might have a slightly easier time to get into probate court faster, but again, I wouldn't, I've seen both scenarios happen, and POAs are perfectly capable of advocating and suing and calling the police or whoever needs to get involved on that person's behalf. So in addition to POAs and guardianship, there are some other sort of, let's call them lesser restrictive alternatives that I had listed on the outline here. And these aren't mutually exclusive. So sometimes people use POAs and some of these other ones. So you can have joint ownership. You can have a joint bank account with somebody and help them manage money that way. If you have their POA, you don't have to jointly own the account. You can be a user on that account without owning it yourself. But there are always going to be circumstances where one arrangement is more advantageous than the other. So these are just options. I'm not necessarily saying that they're applicable to everybody, but you can jointly own property without a POA, and that's fine. So like a joint bank account is the most common one. You can also jointly own real estate, or other assets like that. You can have trusts set up, so fund a trust for somebody and be the trustee. That's another private arrangement that does not concern the courts directly. You can have shared living arrangements. You can be, if the person who has the disability is receiving services from Buddha, then you can also designate a parental successor. So Buddha, at least the Rhode Island Department of Health, will honor another person who is not a parent to help make decisions relating to anything that falls under the Department of Health's rubric. So, medical choices, placements, benefits, that sort of thing. So there are a number of options out there for managing someone's affairs and helping them to navigate all the decision-making that needs to happen without necessarily a POA or a guardianship. Although I would typically say that the powers of attorney are just so effective that I don't know why anyone wouldn't do them. There is another option called supported decision-making, which, again, this is just my editorialization. They're fine. They're like what I referred to before as the advocacy power of attorney, where the person who's doing supported decision-making can't make decisions. They just help the individual to come to a conclusion. A power of attorney can do that too. So the POA has the authority to act on their own, but doesn't have to, right? Just because I might be somebody's agent doesn't mean that I can't just walk them through the process and have them sign. So there really isn't something that a supported decision maker could do that a POA can't do. So I'm not a huge fan of them, only because, and that's not to say that there isn't a circumstance where supported decision making is great and a power of attorney is unnecessary. Sometimes that happens, right? If the individual is so high functioning that they really don't need an agent, and maybe there isn't an agent who's sufficiently trustworthy, then maybe supported decision making makes sense. But again, because of my default, again, just my editorialization, I think every adult should have a POA. Then I don't know why, if you already have POAs, I don't think supported decision making adds anything of value. It is a lesser power, or it's not really even a power. It's just the right to sort of counsel somebody and advise them on their decision making. So, but anyway, they're all valid things to explore. And again, even though I say I generally don't think that they're all that helpful, that doesn't mean that for particular people they're not absolutely great. So we still explore it with everybody, but in most cases, the POA would render supported decision making moot. Great. So the next, I guess I'll just move on, but if anyone has a question about the guardianships or POAs or anything else, just shout them out. But I'd like to transition a little bit to the next topic, which would just be benefits. A lot of people are going to be considering means tested benefits when they turn 18. And while there isn't time to get into the minutia of every benefit program out there or even all the rules, I can talk in broad strokes about the most common ones. So most people who have a disability, who aren't going to be able to work or not work enough to support themselves, are going to be eligible for SSI. And that is the federal government's program. It's disability benefits for individuals who can't work enough to support themselves. If you get SSI, you are automatically eligible and will be enrolled in Medicaid. So you will get not only a monthly stipend of money, but you will get free health insurance in the form of Medicaid. And that is also, by the way, your pathway to Buddha for adult services, which I'll get into a little bit later in the discussion. So you have to be on Medicaid to get adult services through the Rhode Island Department of Health, but SSI is the most common benefit program out there. However, it does come with some significant restrictions. So it's not an automatic decision that anyone who has a disability should be on SSI. SSI recipients can't have more than $2,000 to their name. And that means not just money that's in their bank accounts, but money that might be in a sock drawer or an old, a savings bond that, their grandmother purchased for them decades ago. You have to add up everything that that individual owns effectively, anything that's real cash anyway, any kind of monetary value, and it can't be more than 2,000. If they cross that threshold, they are rendered ineligible and they will be kicked off the program. So until they spend down and meet that poverty definition, because again, it's the idea is that it's poverty based. Medicaid, some people are independently eligible for Medicaid and they don't pursue SSI. So if you have a pathway to just get the health insurance, Medicaid alone typically has a cutoff of 4,000. So if you're only, if you just pursue the Medicaid and you get that, you may be restricted to 4,000 instead of 2. But those thresholds have to be, really looked after and respected, because if those government entities get wind that the person is over-resourced, then they will be kicked out of the program. And in some cases, they may actually owe money back because they might have been paid incorrectly. So if I am over the limit in January and they don't find out until June, they might say, well, we've been overpaying you. You've been ineligible for all these months. And so you might owe some arrearages, or there may be other consequences. To the extent that, again, you're getting services from Buddha, that can also be jeopardized. So anyone who's making the decision to pursue SSI, which again, it's not a bad program, I just want everyone to be aware of the restrictions. You have to really make sure that their money is managed appropriately. And so what does that mean? That means in the short term, anyone on SSI is going to have to open a special bank account called a representative payee account. Sometimes people call it by its more general type, it's a custodian account. A rep payee is one type of custodian account. It's just a bank account. You can go to just about any bank and open one, but Social Security decides who the rep payee is. And it's usually the person who's on the application, but they don't care if you're guardian. The person who they name as rep payee is going to be in charge of the Social Security money, not the guardian necessarily. Sometimes they're the same person, but you can't just assume that because you've been appointed guardian that you are automatically going to be designated the rep payee. Once you have that, once the rep payee status is granted, that person is the one responsible to ensure compliance. And things that can frustrate that. So people on SSI can work, but they're restricted to how many hours they work. If they work, their benefit might get reduced. Similarly, if they're given things of value like free room and board, their monthly stipend would be reduced. There is a whole plethora of rules and regulations that Social Security puts out there. They're informally referred to as the POMS, the Program Operations Manual. So anyone who wants to find a fast cure for insomnia can Google that and go through all of the many POMs that are applicable. But look, it's very manageable if it's done with planning and care, and things can be done to manage the flow of money so that it doesn't build up. Now, most people don't have a problem. The money comes in, it goes out, and there's not a problem. Sometimes it just goes out to room and board. Sometimes it goes out to other things. If it does start to accumulate, though, and the person can't spend it all, then there are some options that you have. The first and easiest one is to create what's called an ABLE account. So that's a special kind of bank account. There's a specific website. Every state has their own version of ABLE. So you have to go through the state designated entity. Once that bank account is created, you can shelter up to the gift tax exclusion amount every year. So it's the amount of money that you can legally give another person without it affecting your tax liability. And that currently is $17,000 a year, approximately. Next year it'll go up. It always rises with inflation every so often. So usually annually it'll go up. But you can put that money, that amount of money into the ABLE account each and every year. And from that ABLE account, anything that's in there, Social Security and Medicaid will ignore it. So it's a way that you can save up the recipient of the disability stipend can save up for, like, let's say, bigger ticket items. You can save up for, furniture that's going to be more than $2,000 or whatever, a vacation, equipment, whatever you want, really. There aren't really particular rules about how the money can be spent out of ABLE, as long as it enhances the quality of life for the account holder. So it's a great tool. The one caveat, though, and you're going to see that this is a recurring theme for a lot of the special needs planning options, but not all of them. Once the account holder dies, Medicaid will get paid back first from whatever's in that account. So if you've managed to save up, and I think the lifetime limit in that account is 100,000. I don't think you can have more than 100,000. And Medicaid has a tab for, let's say, 500,000. They're going to take that money at death, and no one else will get it. If Medicaid hasn't been utilized, or they've been paid back and there's still money in the account, you can designate beneficiaries to get it. But for the most part, ABLE shouldn't be used as a long-term vehicle to save larger sums of money. It's just to sort of medium-term money to save up for things, or to have sort of a cushion beyond what the 2,000 or 4,000 limit that might be applicable to you will afford. So it's a great relief valve, especially if you get it like a surprise small inheritance that's big enough to make you ineligible. You can stuff the money right in ABLE most times and avoid an eligibility problem. If ABLE can't work, or you've already utilized ABLE to the maximum, you can create what's called a first-party special needs trust. And sometimes we refer to that by the code number. It's a D4A trust. And those are trusts that can take money that belongs to the benefits recipient and that would otherwise make them ineligible. You can shelter the money in that trust. There will be a trustee, though, and that trustee has total discretion to spend the money. It has to be always spent for the benefit of the individual with the disability, but ultimately the trustee can refuse. And as long, that's what keeps it sort of out of the recipient's control. And Social Security and Medicaid will, again, if it's validly created, they will ignore the money in there, and there is no upper limit to how much can go into a D4A. But again, when the recipient, when the benefits recipient passes away, Medicaid again is first in line to get paid back out of it. So in addition to those options of creating a private trust, there are entities called pooled trusts that will do all the trust work for you. So instead of having to pay for a custom trust to be created, there are nonprofit organizations that sort of run their own version of a trust. You sort of buy in, as you create an account, and it can be set up to receive money in the same way. They act as trustee. They get paid by the interest that all the separate accounts generate, and they do all the work. So it's a cheaper way to do it. You just don't have the control. You're not the trustee, or the family member won't be in charge, so to speak. However, the same rules that govern trustees are going to apply to both. Trustees can't do whatever they want. Social Security has a whole bunch of rules about what trustees can and can't do, for anyone who's receiving the government benefit. And so in both cases, compliance is going to be required. There may be times when an institution like a pool trust or a bank serving as trustee imposes their own additional restrictions to make management more efficient or to take less risks. But for the most part, they're both equally valid options, and the right one just depends on everybody's circumstances. Outside of that, and this kind of sort of dovetails into the special needs planning for parents and family members. If you don't want to put money sort of in the government's reimbursement path, you have to start thinking about money that you might be leaving to your children in the form of an inheritance, because an inheritance will knock someone, a recipient of SSI, off of benefits. Same with Medicaid. So parents or family members can use a different kind of trust called a third-party supplemental needs trust. And the idea behind those trusts, they work very similar to a first party, but they don't have payback. So the idea being that if I'm leaving my money to my child, right? If my child inherits directly from me, well, as soon as the money legally belongs to them, the government has, a right to it, to either knock them off the program or say, shelter it in a way that gives the government payback. So the alternative approach, if I'm the parent and I don't want that to happen, is I create what's called a third party trust, where I say the money never goes to my child. They don't inherit. I actually write them out of the inheritance. This trust inherits instead. So the trust is not the child. The trust is for the benefit of the child, but it is not the child's money. And again, the trustee has total discretion to never give the child a nickel if that would be in the child's best interest. So because of that absolute discretion, because the recipient of the benefit can't demand the money, the government has no recourse to it. It never became theirs. And so when we use these terms like first party and third party, the individual with the disability who's receiving the benefit is the first party, right? The government is the second party. Parents and family, we are the third parties. So it's third party money. It's my money. It doesn't belong to my kid until I die, and I can reroute it so that it never belongs to my kid. It goes to a trust that is set up only for my kid. And I know that sounds like a silly distinction, but it means all the world. It would be, to use a good practical example, if I bought you a car and gave it to you and transferred title to your name, that's your car. You're financially responsible for it, and it's legally yours. I have no more connection to it. If you're on benefits, that may or may not impact your benefits. However, if I buy my own car and simply toss you the keys and I say, feel free to treat this like your own, but the title always stays in me, and it's technically my car, it's legally my car, I'm just letting you use it and treat it as though it were your car. Well, now your creditors can't have at it because you don't own it. Just because you have the right to use it doesn't mean you have the right to own it. And so that's sort of the theory behind a supplemental needs trust, is that you can set up a trust for your children, for your loved ones, that takes your money that can only be used for their benefit, but at the same time, since it never passed through their legal ownership, the government doesn't get paid back at the end. And that's nice because then you can sort of write the end of the story. When your child passes away, you get to decide who gets the rest of the money that's unused. Additionally, it's just a way to ensure that the inheritance is not going to disrupt their benefits in any meaningful way, and that money is used to supplement their life. So anything that their benefits don't pay for, the trust can typically step in and fund. So you can,
Do you appoint somebody to be
the trustee.
the trustee?
Yep.
In the third party?
Correct.
Okay.
So the parent, whoever's money it is effectively choosing the trustees. And again, you can use a pool trust for that purpose. So pool trust can be set up as first party trust or third party trust, or you can do a private one, first party or third party. So there's a lot of options to make sure that an inheritance doesn't cause complications with means tested benefits. Now, of course, if you're not on means tested benefits, then this stuff doesn't necessarily matter, although a trust can still be a good idea, even if the adult child who has a disability is not receiving any kind of means tested benefits. So it might be that the person worked long enough and they eventually go on disability, but it's SSDI, the same kind that anyone else would get. If you're hurt or you're sick and you can't work, but you paid in enough quarters, those ones don't have restrictions, or, so that an inheritance isn't going to frustrate your ability to collect. Much like unemployment insurance. It's a form of insurance. You pay in, you take out. However, a trust can still be a good idea if the person is either not able to manage money, or there's a worry about undue influence when the parents or natural supports aren't there. You can still set something up in a trust so that a trustee can sort of be the safeguard and make sure that the money is spent the way that you intended. So whether benefits are at play, usually special needs planning makes sense. And one thing in particular is the third party trust can be turned on and off. So while the recipient, the beneficiary, is getting like an SSI, then the trustee will follow all the rules so that it's not available. It won't make them ineligible for the benefit. As soon as that same person decides for whatever reason to stop taking SSI, to go off of government benefits, then it can function like a regular trust. There'll be fewer restrictions. The trustee can maybe give them cash directly, or we'll just have more, there's just fewer rules to follow, I guess is what I should say. So while the benefits are at play, the trustee will have to abide by all the government imposed rules to not risk the benefit. But when the benefit is no longer needed, or, for whatever reason, the trustee then doesn't have to follow as many rules and can provide more direct support. Questions, comments so far? I know I gave you guys a lot to chew on there. Go ahead.
So actually, so if I remember, it said, so a lot of the benefits out of, and I hate that acronym. BDH.
Buddha.
Buddha,
Yep.
okay, out of Buddha are funded through Medicaid, so to get those, they have to be on Medicaid?
Yes. So there's a separate eligibility to get adult services through, we just call them Buddha because it's hard to say BHDDH all the time. So, but it's hard to, well, I should say eligibility for Medicaid is required because that's what pays for the services. In other words, the state gets most of the funding for these adult services from Medicaid. And so if you're not eligible for Medicaid, you're not on Medicaid, then you can't get Buddha, even if you otherwise qualify. So Buddha has their own criteria. So being on Medicaid isn't enough. It's just a prerequisite. Once you're on Medicaid, you have to separately apply to the Department of Health. And if you meet their criteria, then they will award you the benefit and you'll get these adult services. It's typically a stipend. It's it can be a substantial amount of money to pay for workers, for people to come and help the individual perform all their life tasks, get them to work, help them live independently if they otherwise couldn't, take a lot of the load off of the natural supports so that they can get used to the idea that one day they may, their parents will pass on and they will still have a support network that they're used to interacting with. So it's a great tool. It can be very, very valuable. So I encourage everyone to at least look into it. It helps a lot of people stay independent or as independent as possible, even for a lot of practical things like transportation, cooking, cleaning, etc. Other questions or thoughts? So while you guys are thinking about it, I'll just make a few other general comments. So the special needs planning is a very specific idea. It's a very specific consideration, but more broadly, and you may already know this, but I do have some information in here about just, estate planning in general. So when people pass away, their assets need a place to go. So whenever somebody dies, whatever they own will find its way to a new owner somehow. And not everything takes the same pathway. It can if you do your planning, but there are basically three categories, and it's in the material about how your assets will transfer. So the first one is by way of contractual relationships. So for example, if you have a trust is a kind of a contract. If you put your assets in a trust, the trust owns the assets. And even if you die, the trust will still have a trustee, even if it's not you. And that trustee will be able to administer the money and get it to the beneficiaries, however the trust determines. You can also have other kinds of contractual transfers. So bank accounts can have what's called a transfer on death or a payable on death designation. If you have an individual bank account and there's no designation, well, that'll go through probate. But if you do a TOD, you can pick who's going to get it and it'll just transfer automatically on death by way of a contract. But again, that has to be actively sought out and planned for. A deed, yeah, go ahead.
There's a different acronym on real property for that, right?
For real property is different. It's a deed. You'll have joint ownership or some kind of a remainder ownership on a deed.
Yeah, I'm trying to remember it's on my tax bill. It comes in and I'm trying to remember what it was.
Sure. So for example, if you own property with a spouse, your deed will say that you own it as tenants by the entirety. You can also be a joint owner with a non-spouse. That's okay. That means the survivor just inherits it all. You can own as tenants in common, which isn't a form of joint ownership. But the idea is by way of a deed, which is again another type of a contract. You can pick a successor to own this asset. If the assets don't pass by contract, or I guess a beneficiary form is another one. A Benny form can designate who will get like a life insurance policy or your retirement account, if you have one. Those are all designated by the account holder, and as a matter of contract between you and the entity, they will pay whoever you designate. If a contractual relationship is not in play, then sometimes your assets will then pass by what's called an operation of law. So for example, if I jointly own a bank account with somebody, the joint owner will automatically own the whole account. The survivor takes all, so to speak. Also, if the person passes away and their assets have nowhere to go, and you don't have a will, the law will effectively write one for you. We call that intestacy. So your assets will go to your next of kin. And there's a formula to figure out who your next of kin are. It changes constantly. You measure it based on what family relations you have on the moment that you die. And so typically, if you have children, they are your next of kin. Spouses have their own categories. So if you're married, it's your children and your spouse. Even though spouses are not next of kin, they have their own separate category that would take. If there's no children and no spouse, it's your parents, if they're still living. If there's no children, no spouse, no parents, then it goes out to siblings. And then it would be like, grandparents, aunts and uncles, cousins, it goes outward. So you can think of it as, in layman's terms, you look down, you look up, and then you start looking out. And as soon as you find one person that's in that class of people to take, that's your heir.
So kids go before spouse in the hierarchy of,
I'm sorry?
kids go before spouse?
It's not before, they take contemporaneously.
Oh,
It's not even. So spouses, and it's in the materials. So the spouses are entitled to, for example, if there's real estate
yeah,
that the decedent owned, the spouse, like assuming the spouse wasn't on the deed to own in their own right, the spouse has a right to a life estate. They can stay in the real estate for their whole life. They also get, usually that's like the first 50,000, and then whatever's left, they split equally with the children, with the heirs, so to speak. So spouses don't automatically inherit everything. That's not an automatic thing in Rhode Island. And so one way to solve that problem is with the third way that your assets can pass, which is a will. So if it's not contractual, it's not by operation of law, it's by will. And so that's why we would generally recommend everyone, like a POA, should have a will, because you avoid this idea of having to worry about who your heirs are, because again, you may not know who they are. In fact, there's a term in the law when someone dies and they don't have kids, they don't have parents, they don't have any, like immediate family, and you have to really go out to some remote relative that maybe the person didn't even know. In the law, we call those the laughing heirs, because they're going to inherit something and they may not have even known the person, right? And so the legal term is actually the laughing heirs, or at least that's how they're referred to in the cases, right? So you can wipe those people out in a will. So once you have a will, anything that your probate estate controls will go to whoever you designate in the will. Keep in mind, a will does not supersede those other forms, like a contractual relationship. So if I designate my retirement account to go to my spouse, and then I get divorced, and then I change my will, so I say everything's going to go to whoever, my best friend. Well, if I never change that beneficiary form, the ex-spouse will still get the retirement account. It doesn't matter what your will says, what your intentions were. It doesn't matter if you remarried. The contract forms will supersede. So it's always very important. Estate planning isn't just as simple as signing a will and calling it a day. It really does take an analysis of all the assets to make sure everything finds its way to where you want it to go. And you can think of estate planning as just building, they're like connections or bridges between your assets and who needs to get them. And which connection or which bridge we use is going to depend on the circumstance. Sometimes for some people, trusts are great. For other people, you can accomplish the same thing without a trust. So I know a lot of times we hear people will call up and say, I need a trust. Okay, what do you need a trust for? I don't know. I'm just told you got to have a trust. So, well, maybe the answer is maybe you do need a trust, but also maybe you don't. And we always like to try to give people what their options are. So here's the pros and cons. Everything in life, in my view anyways, trade-offs, right? So trusts are going to have benefits and they're going to have drawbacks. And so are the other options that you'll have. And the idea is to inform the clients about what the pros and cons of all your choices are going to be and let you make the best decision and spend the amount of money that you want to spend and save, hopefully, the amount of money that we can project out. Estate taxes are another one, another common issue. In Rhode Island, we have an estate tax. Technically, there's a federal estate tax, but the federal estate tax has an exemption that's very, very high. So it's like 13 million per person. And so most people won't be, right. Most people aren't going to be in that territory. However, in Rhode Island, the estate tax exemption is only 1.7 million per person. And you might think, well, 1.7 still sounds like a lot of money, but they count everything. They count your house, your retirement account, your bank accounts, any life insurance that you have, literally everything to your name. And when you add up all of those things, oftentimes you might not be thinking, oh, I have a $500,000 life insurance policy or $1 million life insurance policy. Well, you're already most of the way there, or a good chunk of the way there, even though that money, you never actually see it, right? So because of that, you can try to do some mitigation of that estate tax. There are options. I can't get into them all tonight, or maybe even many of them, because that's not really the focus, but that's also part of this, because the more you pay in estate taxes, the less that's going to be left over for your children, especially anyone whose special needs trust you're trying to fund. And so you always want to take that into consideration. And again, the estate planning can help you do that.
What's the portability on there?
Portability is a great question. So at the federal level, I said you get 18 million per person. Married couples have this superpower where at the second death, the surviving spouse can say, I'm going to elect to use or their executors, whatever, could say, we're going to elect to use the second spouse to die is 13 million, and the first spouse to die is 13 million, all at the same time. So like, how does this play out? At the first death, you have a married couple. First death, the surviving spouse, assuming they inherit everything. If there's portability, you don't have to worry about that. It's a tax-free transfer because usually there's no estate tax if everything goes to a spouse. So tax-free transfer, great. Well, if that tax-free transfer put the surviving spouse above 1.7 million, what Rhode Island allows you to exempt, well, now that surviving spouse has a problem because in Rhode Island, we don't have portability. So the surviving spouse might inherit all of the assets that the couple had, be above the estate tax threshold, but only be able to use their own individual shelter, not both spousal shelters. Does that kind of follow? So in order to take advantage of each person's 1.7 million in Rhode Island, you have to do a special kind of tax planning. So trust is one way to do it. It's not the only way, but the idea is that at the first death, some of the money has to go to either to a non-spouse or to a special trust for the spouse, but also for the kids or for non-spouses. And so as long as you're pushing some of that money out at the first death, you can use the first to die's exemption up, or enough of it up, so that the surviving spouse won't get whacked with a big estate tax. Because that's usually what'll happen. Like, let's say you have a couple, they're worth $2 million together. Spouse number one dies, spouse number two inherits. Well, now I've got a spouse worth $2 million, but they can only exempt 1.7. They didn't do their planning, that estate will owe a tax. But with the planning, that same estate, $2 million could owe no tax. So the planning can help, especially the farther above you are. So right now, two couples can exempt about 3.4-ish million if they're using both of their exemptions, if they need to. There's always legislation pending to try to raise Rhode Island's exemption. Massachusetts even just leapfrogged us and went up to we used to be a little higher than Mass. Now they're up to 2 million per person. There is legislation pending right now to raise ours to 3.6 per person, but contact your state representatives and senators if you want to raise it, because again, when people start realizing that none of these numbers keep track with housing increases because they count the value of your house. So if the value of your house exploded over the past 10 years, that might push you over the edge. Your retirement accounts, your life insurance, whatever you have, it's a real consideration. It's really not just for the rich or whatever. But there are options to try to mitigate it. Cool. Sorry, I know this stuff is really dry. And I try to give you guys as much information without putting everybody to sleep, but I do appreciate everyone's time and attention. Again, if there's more questions, just fire them out at me.
So, well, you actually had a note here about the federal exemption expected to sunset, as in go away?
Yeah, not go away. So essentially when, I believe it was when, the federal exemption used to be, $5 million and then it would start rising with inflation. And I believe it was under the Trump administration that they raised it to 11 million per person. And the reason why it's at 13 now is because it's pegged to inflation. So every year it goes up a little bit. That law that increased it from 5 and change to 11 is going to sunset at the end of 2025, which means it's going to revert back to what it would have been had they never done that increase. So with inflation and, to keep pace with it, it's probably going to be about 8 million per person if I had to take a rough guess, if this sunset goes into effect and Congress doesn't act. I have no idea what Congress is going to do at the end of 2025. We're at least one, if not two election cycles away from, who's going to make that decision. So your guess is as good as mine. Depending on who's in Congress and who's in the White House, they might extend the exemption and raise it up more. They might lower it more. I have no idea, but at least through the end of 2025, most people won't have a federal estate tax problem, even if they do have a Rhode Island estate tax problem. And after 2025, if the sunset goes into effect and Congress does nothing, still most people aren't going to have a federal problem. But again, Rhode Island is still on the table. However, if Congress decides to radically change things, I have no idea. They do tend to tinker in very egregious ways from time to time. So I don't know if you guys, maybe the way to end is on the Secure Act. Who here might be familiar with the Secure Act? You guys have heard that?
Zero.
So it was a pretty, I mean, again, politics aside, a pretty, in my view, unfair piece of legislation, the way that they did this. Effectively, it affected how your retirement accounts will be treated when they pass on. So it used to be that your spouse and your children, if they inherited a retirement account, they could what they call stretch it over their lifetime, which means you just take the minimum required distribution is all you have to take out of that account. The rest can continue to grow in a tax deferred basis, which means that the money, if it's invested prudently, can effectively double, if things go well, every 7 to 10 years, if the market is doing what it usually does. And stretching that over the lifetime can really, an inheritance of $100,000 could turn into $1 million on over the course of a lifetime if it wasn't touched, other than the minimums, right? Something like that. These are rough numbers. The Secure Act got rid of all that, and they said, okay, no. Spouses can still do that. Children who have a documented disability, like if you're eligible for SSI, if you meet the federal definition, they can still exercise the stretch rule, but anyone else can't. So children who don't meet the federal disability definition now have to cash out in 10 years and pay all the taxes, which, if you think about the value of what you're inheriting, how that changes it, $100,000, even if it doubles in 10 years, you get 2, as opposed to something that could have, increased with compounding interest to a much larger number over the course of the person's lifetime. So the reason why this was kind of unfair is because it started taking effect immediately. So a lot of people they oversaved in their retirement accounts because they were such a great way to transfer wealth to all of their kids, only to find out after they were all invested in that suddenly now that's going to be a huge tax burden for many of their children, or people who are inheriting. If you're going to stand to inherit from your own parents, that's going to be a factor to consider, because now you have to take the minimum, but you also have to cash out the whole thing within 10 years. Whether that means taking out about 1/10 every year or waiting until the end and having one mega bad tax year, that's now on everybody. But it didn't give people the chance to plan. So in other words, if it said that's going to take effect, for people who are just starting to invest in retirement accounts, that might have been a little bit more fair. But people who, they
Spent their whole lives doing.
they socked away everything specifically in their retirement account, thinking that this was going to be a great deal. And now suddenly the rules change. So, there's a lot of worry. I mean, Roth accounts are very popular because they're after-tax dollars. They're not supposed to be taxed afterward. But who knows? There's nothing to say that Congress couldn't change the rules on those too. So I would just urge everyone to sort of pay attention and just be cautious, because it's it's not about partisanship or politics, it's just knowing what the consequences are going to be and how they impact you, so.
When did that Secure Act happen?
It happened, that was a bipartisan legislation, I want to say it, 2020, the end of 2020. And they slipped it in at the very, last minute, it had unanimous support because it was a way of effectively raising taxes without saying that you're raising taxes. So the IRS gets their money much, much sooner at much larger, consequence to the beneficiaries.
If you inherited before 2020, though, are you guaranteed?
You still can use the stretch rule because the law only took effect for people dying on or after January. I think it was January 1 of either 2020 or 2021. I forget which, but whenever the law went into effect, it was like that following January, if you died then or after. I want to say it was 2020. So this was something that they definitely put in, but it was bipartisan. This wasn't like a one party thing. It was, they both were like, yep, this is a great way to do it, but nobody noticed because it's super boring stuff. And if you hear the stretch rule, I mean, right, get out the pillow and start. But it's like Ambien, but really then you find out how it can impact a lot of people and then you get it, some people got enraged, but not enough to make a difference. So just keep in mind that that's a thing that's out there. But Rhode Island might raise their exemption, and again, call your representative depending on how you feel about it, because it's always on the table. I don't think Rhode Island makes a ton of money from the estate tax, but we certainly lose a lot of people who become Floridians because of it. So, yeah.
That actually kind of went to my question was, so obviously proper planning here involves both consideration of federal and state rules, as unstable as both may be. So is that also that you have to figure if you're going to do this properly, you should have an idea if you are going to take the Florida rule, or maybe not quite that hot, maybe the Carolinas. How does that, and if you did a plan for Rhode Island, how do you have to redo everything if you're going to change states?
Possibly. I mean, again, I like my comment earlier at the beginning, which is to say a will that's done in Rhode Island, a trust that's done in Rhode Island, they're good everywhere, just like trusts done in other states. They have to be honored because of full faith and credit. However, that doesn't mean that there won't be advantages to updating them when you get to wherever you're going. So I kind of say that, certainly if you've never done estate planning, it's never a bad time to start. And the planning that you put in place usually is made. I mean, if you have a good attorney who does this, regularly, they should be forward thinking. So it's not just a plan for right now. It's a plan that's designed to sort of give you the flexibility to do what you need to do. So, I mean, I always ask people, do you see yourself staying in Rhode Island after you retire? Are you going to move? Are you not going to move? And then whatever those decisions are, we plan around that. And if you're unsure, well, you can plan in for some uncertainty. The more uncertainty in your plan, sort of the less efficient it's going to be, but it gives you freedom. And then, the more definitive you have your thoughts, the more efficient your plan can be at the expense of some freedom, unless you go and change your plan. Right. So there's always going to be pros and cons, but doing it sooner rather than later is always a good idea. And a well-written estate plan can last quite a while. That said, you should at least revisit them, every, I'd say 5 to 10 years, or if your circumstances change. Not necessarily that you'd be buying a new one every 5 to 7 years, but you want to make sure that whatever decisions you made all that time ago are still relevant and serving you well, because that happens a lot. People will make these elections and then they forget. I mean, I know I barely remember the choices I made, 2 years ago, let alone 10, right? So, but a quick refresher, a phone call can do that, right? You go over things, a short meeting, it's worth a conference, the price of a conference with an estate planner, just to make sure that everything is still doing what you need it to do. The laws might change, in which case you might be leaving money on the table by not taking advantage of something that wasn't available to you when your documents were done. But usually things like the basic documents don't change much. Your will is going to stay your will, and it's meant to, it doesn't matter if you own a different house now, it doesn't matter if you moved or whatever, they're designed with that in mind. Again, it doesn't say that there aren't ever reasons to change it, but keep your finger on the pulse at least once a decade, I would say. Whether you actually do anything is another story, but awareness saves a lot of money. Great.
Thank you very much.
Sorry to keep you guys so long here, but hope that was helpful.
Very much so.
And yeah, there's a business card, and if you want to take one and pass it or however,
Way.
you feel free to contact us. Everyone at my office does this stuff and we're happy to help you. Thank you. To start a business or to?
You guys wanna take like 5 minutes, bathroom, snack, water, and then we'll
Take a look.
go through. our
It's something
stuff,
that we
see how
don't do,
fast
we
can walk.
throw you to the right person, so
I
happy to take a look,
Thank you.
of course. I guess I'll leave these extras here in case anyone wants. Yeah, absolutely. I wouldn't do something by default, but yeah, like presumably the person under guardianship would not be legally eligible.
Yeah.
Without a carve out or without some kind of authorization. Well, again, so, you know, Rhode Island is a state that does regulate firearms pretty extensively. And so, you know, whatever you would want to do, you want to make sure that it was contemplated in the court ordinance. So that's something to bring up. It's just like by default, if you don't talk about it, yeah, you can cure it after the fact with another trip to court, but it could be more, it could be more expensive and just more difficult.
Yeah, that makes it worse.
Maybe, yeah.
Well, that's,
Yeah.
I won't claim Laura.
Yeah. Sure. Oh, for sure. So again, guardianships, we tend to look at them as a last resort.
So you mentioned that one of the,
Yeah.
somebody had mentioned, I think it was that.
Ad litem.
No, no,
Oh.
no, it's like.
Oh, it's limited. Limited.
Somebody said it was like CDU thing in Rhode Island, was that the limit?
Limit is not,
I think it was almost like, I think it might have been more than advisory.
the supported decision.
Okay,
Yep.
I think they convert that,
Yeah.
and that seems really helpful. It seems to be lacking a little weight.
It was something that, when I think the movement to get it started happened quite some time ago, but it didn't actually take, you know, come into fruition until recently. So, you know, maybe 10, 15 years ago, it would have been a great alternative to guardianship when everyone just went for guardianship. But now that we don't do that anymore, it's like a lot of things. Sometimes by the time they pass a law, like it's already become moot.
It's gone beyond, yeah, we're past that.
But the proponents of it were super happy about their accomplishment. Yeah.
It seemed like it was, you know, it took a really unhappy middle ground.
Yeah,
It's
it's
not,
not,
it didn't give you enough and it restricted something that maybe is.
I mean, like, there are some very high functioning individuals who really just need an advisor. And you want to formalize that this is the person who you know, if you go to a government office or, you know, they can come to school meetings with you and, you know, hear about your, you know, whatever it is, your. Well, Yep. Yep. Right.
Have the ability to go get the license test different than be able to drive, and, you know, but if you don't drive.
Yeah.
Very different than that, yeah, I mean, you're not. So,
Sure.
Um,
So I do know that RIDE does a lot now with,
yeah,
with that, but it's, to your point, look, when, you know, at age 18, if you do POAs, then, which it sounds like that would be a prime candidate for, the supported decision-making is sort of already baked into it.
yeah,
There's nothing that you could.
I didn't see benefit, it was almost like.
It's only really when the person, for whatever reason, does not want or does not need a power of attorney.
Not saying that he's gonna be on.
All right, is everybody ready? Start the rest of our-
Yeah, that part is true. I would say that, you know, planning comes in stages. So the immediate 18-year-old planning, absolutely, there's some great stuff that you can do at 18.
Well,
that you should do.
In March, I think we need to get started.
Sure, but if he's going for a driver's license, I'd be very shocked if POAs weren't just the easiest and cheapest solution. And then again, once you make the decisions about things like means tested benefits, all the rest of the planning falls into place.
That's
Our last
another
meeting
one,
was
yeah.
on September
Sure.
27th.
scratching my head on
Meeting minutes. Our guest speakers were Ripen and Ability Bridge. They both spoke in depth on what both companies and organizations do and provide to the public. You can look at the full notes, the video playback on the district website and SSELAC school website. The board spoke about the goals for the year, positivity showcase, upcoming events. And what are student ambassadors, school committee meetings, and we ended with the special education director's update.
Anybody approve?
Yeah.
Good, great, moving on. All right, some SELAC goals updates. We have, a lot of our goals were about communication, so we have noticed that we've had much more communication with all the principals, faster communications as well in most cases, which has been awesome. That the principals have been really receptive this year. I think it helps that, you know, we're sticking around. They know kind of what we do now. We're emailing at the same time almost every month. Monthly emails that Eileen will be sending out. Last meeting, we said they were gonna start in October. Life has been crazy. School's been crazy with all the things everywhere. So those will start in January, but everyone should have gotten an email from her about Santa. That she sent out on Monday, right? So that was kind of like our test run to make sure everybody was getting them, everybody was good. And then we're gonna be meeting, Diana, Amanda and us as a board, meeting with the superintendent and with Eileen in January, just to get them up to date on things that we've seen, heard from other parents, and kind of go more in depth than we go in here, just because it's like the nitty gritty stuff. So, any questions? Moving on. Okay. So like I said, one of the big goals that we have is communication, and one of the things we were doing is questionnaires. We posted a questionnaire to our social media and onto our Google website, and from those, the most common concern was communication. So we broke it down to 3 areas of the communication difficulties that families feel they're having. The first one is general, positive, and from therapists. So generally, parents are just saying they want more information about what's going on within the classroom, as a whole and as their child individually. So this is if the child's getting daily notes on those, or if they're getting weekly notes on those. That's kind of individual to the child, but also everybody just wants to know more of what's happening, what their child's doing during the physical day. Where positive communication is concerned, they just want to hear more of where their child's progressing more often than just progress reports with report cards with the IEP updates. Just, they want to hear what they're doing well in school, instead of just like, oh, they're having difficulty here. And then as far as therapists, the really big thing is knowing what the therapists are doing at school and how parents can modify it at home. So, we might hear in the IEP exactly what they're working on, but, families don't feel they're getting enough of that back throughout the year other than that IEP meeting. And so they're not sure how to accommodate, because again, they don't know how their child's progressing. Have they changed it a little bit? So that was feedback there. Next is with the classroom staffing. So this is kind of all over, and we already know some of the answers, but because it is a very frequent concern on the questionnaires is why I am stating it, because that would be a disservice, to the parents that have answered it. So a big thing is changes without notifying parents. We know that there's a lot of movements. There could be teachers out for a day. We know there's paras kind of moving everywhere, but that instability for the children really is difficult, especially those who need that consistency during the day, especially when they're going home and parents have no clue that they were with a different para or a different teacher that day. So that was we got a lot about that specifically. And then also from the parent perspective is just that they feel there's so many teachers within the regular ed classrooms that just aren't getting enough support, because there's so many more children they feel that have IEPs or 504s in the classroom needing that more one-to-one time or accommodations. Again, these are from parent perspectives, and we know that there's funding and there's hiring, all that stuff, but we are saying it because that's what we're getting an influx of things about. And the last one for the communication stuff is with the accommodations and the IEP goals. Many parents feel that while they are sitting in IEP meetings that they are not being heard. They feel like they're being disrespected, and that administration would rather work against them than with them. That they're kind of like, yep, I hear you, but also we're still gonna do this instead. We had like a big lengthy one on that. And then some other parts of that is that IEP goals are more generic versus catered to the individual child. And that plans that are being put out for the child, whether it's a behavioral plan or just, you know, just through a very specific plan throughout the day, they're just not being followed through the way that the parent was told it was gonna be followed through. So that's again with going back to that general communication of what happened during the day, and if there was a staff change, kind of all goes together.
But did you have numbers on these? Because it's always concerning as the principal of one of these schools that you're
Yeah.
talking about. Because I don't hear this or see any. of
We
this
can get you the
stuff.
numbers. We had 15 responses in total, and most of them, the majority of them have all 3 of these things roped into their responses, but we can get you exact
You can
numbers. of
see,
each
like,
thing.
is it high school, middle school?
Yeah, we can see everything. It's all 5 schools.
Yeah, it's all 5
All-
schools we've had
yeah.
responses. I'm
Um,
looking at them right now. I can't share them because we have like anonymous and certain people.
course.
yeah, some people have their
But
names.
we
on
can
them,
break it
but-
down and then take out names and
Yeah.
emails and just send what they said
Yeah.
to the, I didn't want to
Yeah.
like read them out. I don't feel like
Right,
it's
yeah,
right to
that's
read them
not
out.
We could also do data charts to send out too, so that you can see like the actual, how it's going, so.
But it is all-
And thinking about how many students in the school have an IEP, how
Right.
many parents we are engaging with, and how many parents truly feel this way.
Right.
Because it
And there's
feels.
positives on here too. Like,
Yeah,
there are
'cause
positives.
I
It's not
have to
like-
say that
There are positives.
Yeah.
So there are like.
Well, like I said, I put concerns because unfortunately there are way more negatives than there are positives. There's
Yeah.
one
Sometimes
family
we
that
always-
was a
We
positive.
always hear negatives, but
Sometimes
then
we ask for that.
Yeah,
Sometimes I'll say, hey, do you have any positive?
We
comments
did.
or Positive suggestions?
yeah, we asked for both and that unfortunately. we
Yeah, a
didn't
lot of
really get
times though,
many.
the danger with surveys is a lot of times people only fill out surveys if this is plain.
Right,
Oh, of course. That's
You
why
know
we
what I
do the
mean? So it's so
positivity showcase too.
skewed.
Right.
Yeah, it's so
we
sweet.
balance it out.
There's positive things. in the-
Yeah.
There are great things, and with every great thing, there's gonna be not so.
And that's also the why we try to,
But any
Grab
concern
people
should be
different ways.
expressed. I'm
Oh,
just saying that
Absolutely, yeah.
it's a little skewed, I think, just like with the
Oh, absolutely.
survey works.
Yeah.
You know?
Right.
Yeah,
Well,
so-
even if we said, okay, we have 75
Yeah, that's a great-
students who have an IEP in Smithfield or whatever
Yeah.
that number is, and 15 responded, so what's the percentage
Yeah.
that responded? Just
Right.
because it's hard for me to
Right.
sit here and hear that and say,
Yeah, I'm like,
oh my gosh, I want to.
well, that's why I preface it with saying, we know that like, we know all of the things, but because we're getting this feedback is why we're saying it, but we also know, again, that we did get 15 responses out of how many families in the district.
Right.
But because we specifically asked people to fill them out,
We
you
want
know.
to hear that.
yeah.
Yeah.
And I think a strong encouragement, and I know people are saying that they're not feeling heard at an IEP meeting, but a strong, always to encourage people to reach out to your case manager. If maybe that case manager you don't have the best connection with, who's the classroom teacher? Okay, that person you don't, okay, do you have a great connection with the speech pathologist or the principal or whoever is your person that you feel the most heard by? Actually reach out to that.
I was just gonna piggyback on that, and Eileen just, hosted an unbelievable PD on a PD today about getting more parent input involved in the IEP.
Great, yeah.
So what's the next step with the survey?
The next step would be to share it out with everybody. We're waiting until this
Yeah.
meeting, so we wanted to give it like, it was like 2 months. So give it 2 months
we
to
want
give.
to see how much we got, you know, just through social media, and on the website to see if we were getting attention. So now it'll be like an email.
Yeah,
Yeah,
and
we'll
like
go.
definitely Smithfield families. If it's on social media, can anyone just respond to
It's,
it? anonymously?
it has to be a Smithfield family. They have to
It has to be a specific
specifically
family. We have
say,
names and emails. There are some blank ones that we don't know,
Yeah.
you know, but they're pretty specific where you're like, okay. That's a school, or like, they wouldn't know certain things where you're like, all right.
Yeah.
Now, if it was just generic, like this school is awful, then you're like, all right, it could be.
Okay.
yeah, they have to answer very specific Smithfield questions. So, I mean, unless somehow they're Smithfield savvy. Yeah.
Had an answer which school actually our kids went to.
But yeah, it's like very specific to Smithfield, so.
And the more specifics are you planning to share with Eileen so that?
Yes.
if
Yeah.
you want to,
And that'll be part of the January meeting that we have with her and, yeah.
Unless somebody said not to share that.
Yeah, if someone said not to share, that's different. I
Right.
would want to.
Were there any concerns on the questionnaire related to like extracurricular activities, like support in school? Or,
The only
Things that
thing that
happen.
was mentioned was just, about Old County having more unified activities, like La Perche and PVE. That was the only really extra outside of the classroom day.
We just had our district inclusion meeting yesterday, and Mr. Barrett, who's the principal of Old County, and Allison McGregor, who's one of the paraprofessionals there. I know Julie couldn't be there, but
I feel terrible, and I
don't feel terrible.
I didn't even have time to meet with him today, and Allison was absent.
Well, no, they
We
just
took
had,
notes.
they had
Okay,
so many
good.
positive things to share.
Yeah.
They're so open and ready and excited about it. So, you know, some of you who were here, Amanda and Diana were both there. They just are ready to embrace it all and want to get things going too. So they're on board as well.
And I was specifically asking that because I'm curious, Eileen, what the district policy is on supporting kids with extracurricular activities like music shows, drama club, some of these, you know, Lego groups or whatever they're doing after school. It's very much catered towards neurotypical peers. There's not a lot of thought that goes into how these programs are going to support our kids. And it's hard, you know, especially when you're asking questions and you're not getting answers. Because it's a second thought. I'm just gonna say it the way it is, that we're not at the table planning for all children. And it seems like it's a gap. So I'm curious what the policy of the district is on that.
Yeah, so if it's a district-run activity, so for example, all the elementary schools are running math camps after school for students who show gaps. And so if it's a program that we are sponsoring and students need support after school, then that support is part of the plan and provided. If it is an activity that's outside of the school, so if it's a PTO activity, then the PTO should consider students who need additional supports. And I think, you know, that's what we talked about at one time, having representatives from this group be part of PTO so that when planning those events, that there's somebody at the table considering the needs of all students. But in terms of school-wide sponsored events, field trips, after-school dances, proms, 8th grade dance, all of those types of activities, if students need supports, then those are planned for.
So
And
this
provided.
new drama club that's starting up, that's district sponsored, I assume, because I think it's PTO.
The one where, the one at Pleasant View?
Yeah.
It's not district. I think another organization is
It's not
arranging
listed
that.
as PTO. It's on the flyer, it's not listed as a
Can
PTO. event.
I ask Julie something
Yeah.
now? You know, I know that you have the LEAP programs. How is that PTO sponsored? So then the PTO,
Sponsored, but the you know, parents run them and teachers run them. And so anyone here who's a first parent, or not a first parent, actually, is welcome to run a club, run an activity. And so when you're thinking of basing it around your own child's interests and needs, absolutely run one. We always put a second person in there for support. You're paid for your time because the other kids sign up and pay for that. And then any student who needs support, we always provide support for the students.
through the PTO.
Through the PTO, we're a PTA, but through the
Oh,
PTA,
sorry.
through the PTA, sometimes it's a paraprofessional.
Yeah.
We'll put out.
Sometimes it's another student, sometimes it's a high school student,
Yeah.
sometimes a
Sometimes
family
the
member,
actually comes.
a parent comes, or sometimes the child has a pass worker, and sometimes the pass workers come.
Yeah.
So
To those.
If you look at the email that came out from Sandy Barrett, it says PVES sponsored Panda drama, whatever it's called, right? It's definitely identified as a school-based program. And
I'd
it,
have to look into it, I'm not
but
sure.
it's right, because there's a couple parents, and I'm one of them, who was concerned because it's presented to the entire school, to all kids. It's very specific of what the children have to do, and it is not something that's gonna be easy for children that have differences.
Did you reach out to Sandy
No.
and see if your child
Yeah.
came up?
I did, but I wanted to ask Eileen what the district policy is on
Yep,
that.
that's the policy, so if it's a district activities, sponsored, then we would provide support, but if it's not, then that organization or that group or whoever arranged it would factor that in.
So that one you're
Tuesday.
saying is PTO sponsored.
I don't know.
Yeah, Amanda's saying. no,
Amanda
it's not
saying, no,
PTA.
it's not, and I thought,
It wasn't it Alicia?
Alicia's like the stage manager on it, but like if PTO has it, they put it on they would put on. the
Yeah,
flyer.
'cause
I didn't see,
I looked into it and I asked Sandy Barrett
Yeah.
and she thought it was PTO. Cause I
Was your
think,
child denied the, willing, ability to join the phone?
So my point is not that he's denied yet, my point is that he's not been included. My point is that it's been really hard to get information about details. Can he participate? What does it look like? We're planning something that's for the general population, and it just hasn't been thought of. And so asking the questions have been really hard to get answers because there's clearly no plan. That's
How
what
to
it
get
boils
answers
down to.
from the particular people running it?
Yes.
Yeah, we would definitely reach out.
Yeah,
to
or
the-
reach out
I
to the
can stay with
principal.
you afterwards,
Yeah.
because I've been investigating.
Right.
a lot.
But it's more of a district thing, right? This isn't the first time. So that's why, like, I'm asking, like, how do we, even if we start with SELAC, if that's where it needs to start, right? It's a parent-led group. How do we partner with the teachers or PTO or whoever's starting these after-school activities to get them thinking more about inclusion?
Yeah, I
So
mean, I
it's
think
not
it's
so
having like
hard.
that representative, having that voice on those organizations, so that when you're planning an event for the school, I mean, even thinking about, the trunk or treat or, different things that all kids are taken into, consideration.
and if we think about like
So-
PTOs in schools, they're partnered, right? So
Yeah.
like, it's almost like the school can almost, not mandate, but like, if you're gonna have an after school, we should have a PTO or something paid
Generally
for.
good about it, that's why I'm surprised, they're doing sensory friendly
Yeah,
things, they're
that's
always,
Right.
so I'm surprised.
Maybe PTO
that-
doesn't even know, but
I-
I'm not on PTO anymore, so, but it's not me.
Yes,
But I'm just
not-
saying, like, maybe they don't
I'm
know
not
this.
sure.
I know the board, obviously, and they're awesome, so maybe they just don't, and I think they would be willing to pay, but it's something that as a everybody should, like, it's like
Right.
everybody should.
And it was,
and-
it was natural too, like, I remember at La Perch, like, the first time the LEAP program had, it was like, oh, we have to think about that, so.
Because you have to
It
think
had-
about every ability when you're.
Well, in that, every single PTA meeting, we talk about all of these events, right? We
Right.
talk about the
This,
leap and
it
we
just
talk
seems like
about
it
the-
popped up, right, drama popped up out of nowhere, the kids knew about it.
Yeah.
Parents didn't, we got the letter and there's no plan. So it's just, that's why, if that's what it takes, then we go with, there's a parent in each school and you gotta talk to your music teacher, I mean. Personally, it's in David's IEP, so I'm not concerned about being able to get support for it, I'm thinking more of the bigger population.
Well, if it's not a district, if it's not a school, like, district initiative, it's not an IEP. The
So I think
IEP,
that finds that-
the
so that's what
IEP
these intents are for though, because the email clearly states Pleasant View sponsored Panda player, blah, blah. There's nothing about PTO.
so
And you and
I,
I have been in communication. I talked to Mrs. Vieira. She's gonna reach out to the PTO. She's had meetings with
okay,
Sandy Barrett. Prior, so she knew about it, but as far as, is it PTO, is it school? She's addressing the PTO at the next meeting. I don't know when, is it next Tuesday? You're not on anything?
I just, how?
Not yet.
In the email, it says that it's our new PVES Musical Theater Club. That's what it says in the email, the
It says what?
PVES Musical
So-
Theater Club.
But you've got children excited about it, right? And now we're gonna say we're not gonna support it because it's not.
And I don't think that was what she said, that they're not, but they're excited about it. I think they're needing to find out.
But there's.
I can't speak to, I can tell you what happens, but I
All I'm
can't
saying
speak to
is
that
there's no plan,
particular
And that's a
event.
district.
Plan for what, though? I'm not sure, I'm not.
So I wanna specifically address it to Eileen, if you don't mind, Julie, because from a district perspective and like.
As a
looking at the
district, I
policies-
wasn't involved in that, like,
Okay.
the district didn't put that together,
So.
is what I'm
if
saying.
The school, if the individual schools are putting something together, like this drama thing, they don't have to go to the district to let the district know. that they're
No,
doing
it's
this.
whatever that organization has decided to do in conjunction with the school.
So it's school.
Like, we
level,
don't
not
control
theory.
like the PTA or PTO events, that's their arrangement, that's not the
We have to
district.
get approval, but it's usually like. I never went to, like, just from running like a PTO, I never ran to like Eileen or it would be like building level probably.
Yeah.
Building level, like, I'd have to speak here. This is back on like Kathy would have to approve every single. item that I ever did, but that's so.
I mean, it's a gap is the bottom line. I think we should be supporting kids, whether it's district, it's PTO, it's YMCA, it's whoever. Like, as a district, we should want our kids included, we should make it easy. And it is not.
So the question is, that SELAC is going to be a representative in that.
Yeah, that would be the.
What
next
is what the question is?
As an advisory.
How do we become that and practical?
Come up with a plan to be, if, we tried.
I just actually talked to Mr. Barrett about it yesterday and asked him, reason to get
So fun.
our hands more into, like Old County, we don't really have many parents that come except for Jessica. And sponsored us to go to a PTA meeting and.
Maybe there's something else.
Yeah, so he had said, maybe we'll try to get you there just to show up and say, hi, we're not scared, come to our meeting. I don't know.
Maybe it could be something as simple as.
Oh,
us
you don't know.
working with
PTO.
PTOs or any after school. We have a representative.
Oh, all right.
I'll be there.
I'll come there Saturday.
She did a statement on someone's no hard.
I know.
Logan said absolutely
Yeah,
not.
Jack's
That's not
like-
part of the stage.
We'll get back to it.
Yeah.
Maybe.
Oh,
No, if Ben's old enough.
Yes.
Yeah,
yeah.
I mean, I go to the person who's running it and I say, as a parent, I want my son participates in everything in concert.
Right.
So I say, and teacher, let's, like, how do we do this? And that's like why I directed you. And like, in open house for the middle school, I talked to Mr. Burns, who ran it, he said, hey, I want my son to participate this, what accommodation, and they're willing to make accommodation, so I.
I think if you look
Through SELAC, we could email
Right.
them the question too.
I think too, and part of it is like a parent, like as a parent, I'm like, you shouldn't have, you shouldn't have to, you know what I mean? It's like,
But other kids, like, some kids cannot be.
Right, right, absolutely, yeah.
Like,
Right.
because this sounds.
You just wanna be thought of, right.
So you have to be mindful of what, like, your son, daughter, and
Right.
be accustomed to, and just see how we can make this happen. Like,
Right.
if you're doing the music that they're following, no, but if you're on stage with them, yeah, so, I think that's really sitting with them and. I don't know, taking the drum when you can't drum. But like, you know, yeah, it's like that when I'm really, that's cool now.
Yeah.
Right.
For sure.
Positivity showcase.
So, the positivity showcase, we awarded 4 teachers with the Positivity Showcase Award. In September, we gave Mrs. MJ Positivity Showcase Award at her anti-day assembly. In October, we awarded 2 teachers who both had multiple nominations. Mrs. Kayla Bernardin, which is at Gallagher, she's the ISD teacher, and Mrs. Michelle Nonis was at La Perche, who was a 3rd grade teacher, but not anymore, but she was when she had the nomination. In November, we awarded Mrs. Dottie Corbeil at Old County Public School, and she also received multiple nominations, so that's why because the last meeting I had said we were going to do double in November, but I realized Dottie had more than I thought. So. She did, yeah. So now we have created a panel. We've been in touch. We are meeting actually Monday. And then when I realize, we figure out what schools I will be in touch for December. The plan is 2 in December, 2 in January. We have 10 left. We've gone through. So we're gonna pick out of 5, which are time stamped. So we'll do everybody in order. So we're not jumping around. And, but if anybody else here wants to be part of that panel, just reach out. If you are available Monday night, you can jump right on. And,
It's a Zoom call.
it's just a virtual.
Yeah.
Yeah, I'll send the link out. Yeah, I just wanted to get a day of time. And then honestly, the only other thing is if anyone knows any local businesses, we purchase small gifts and flowers for everybody that has,
Handmade bags.
and we make handmade bags for everybody. But if anybody knows anybody that wants to donate anything, we're completely open to it. I have one company that donates candles. Besides that, we're open to that. Just reach out to us. Awesome. Moving on. Ability Bridge Foundation. So Gwen came and spoke last time, and I just kind of wanted to touch on some things that have come up since then. So now they offer a buddy program, which Ella is part of. But you can sign up through their Google form, which is on their Facebook. So they are primarily taking Smithfield student children, however, but their stuff kind of got blasted out. So now they've extended it a little bit to Johnston, Foster, Gloucester, and North Providence within reason. But you know, it's not a babysitting service. So that has kind of been like a miscommunication just in some of their wording. Again, these kids are great. They're high school students. They just needed some help with their wording.
Yeah, I think only one of them drives.
So,
that's-
right, only one drives.
So,
That's the other thing.
That's what they're trying.
Right, so it's really just as like a helpful hand, like if you're somewhere and just need that extra like older sibling, basically, to help out, is what they're looking, like, that's what this program is. Not to just be like, hey, here's my child, good luck for the
I told
time.
Ella I'm just gonna
Um,
keep submitting her when I want as much grace.
A lot of the volunteers that are part of the group were part of the SELAC CPR class in October. So they are all, those guys are all CPR certified, but still, don't leave them. So, they're doing great, but still. And they're gonna be having a large buddy event in January at Extraordinary Kids Therapy. There's gonna be more information to follow. But just so you know, that's gonna be in like a bigger, so there's gonna be a lot of people at that event. Some other things is that they have an Amazon wish list on their Instagram. I think it's also on their Facebook. I think I saw that today. Just, you know,
They're asking for donations in lieu of like money for the buddy program. They're not asking you to take money. They're just looking for you to pay it forward to the next family for crafts.
Yeah, it's a
You
craft.
know, because they're purchasing everything. They came to our house and made like Christmas ornaments with the kids on the day off.
GoFundMe, page where you can make donations.
Oh,
Yeah.
okay.
Yeah, I think that's the goal too. And just to help them kind of get seen more, we are gonna add them to our SELAC Google website. And so there'll be access on there too, because there's a lot of families not on social media. So just so that they have another outlet, so you'll be able to find all of their stuff on there too. Not tomorrow, I'm looking for like January 1st, their page will go live, because we're gonna work with Gwen to make sure it's what she wants it to look like. You know, give you an update.
Yeah, so we have sensory friendly arts and crafts that are happening at East Smithfield Public Library. Kristen's been awesome with that and cheering that on. The one in December is canceled because we have our sensory event, so we're kind of looking at the amount of events we have and looking at how many different, like, the amount of people that come, and so we're gonna try and see you know, when to have. The Santa is
The sensory friendly is the, that was the 9th, it was the Saturday after. Last year, not many people came because everybody had come to the Santa event, and I will be very honest, I was just wiped out by the time we were the weekend later.
It's a lot. And then the color run is May 4th. I'm just gonna keep saying it every meeting. May 4th is the color run. The rain date is May 5th. This year we have all the trails as well as the soccer fields, which is gonna be fun. We're gonna expand it. I've already been in talk with the Autism Project, Down Syndrome RI, a couple other vendors to try and lock them in, and because last year we locked them in and then they kind of forgot about us and they had other events. Special Olympics is gonna come this year. And I kind of made a calendar and just send them like, hey, add this to your calendar. So hoping to make it bigger and bigger this year, and maybe to Eileen and Julie and whoever else is in the inclusion meeting to make this a part of the inclusion committee and have the schools take on a role at the color run as well, which would be awesome to have all of the schools come together, because that was the main
goal last year.
The main vision last year was to have each school come up with a booth. And then we didn't know how to, I didn't want to put anything on teachers. Teachers have so much as it is, so we kind of took it on and we're making billboards and signs but it'd be great to have the kids involved and to have even buddies or people who want to be a part of it. It's not mandatory, obviously, but like,
Because it's on a weekend, so.
it's on a,
mandate.
or even just to make a poster, have the kids make like a poster and we hang it up.
Right.
Or,
With the name
just
of
so
the
each
school
school,
is
just so each
represented.
school has recognition. Yeah, so not to mandatory to come, so we can, like you said, but.
Yeah,
Right, we'll
like,
set up
we
the
had
rules.
talked to Eileen last year, like just having like the school logo and having like all the students sign a poster board. Or write something in some way, just so that each school is represented and it shows that it is still all.
It's like part of our shared experience that we've been talking about.
Right,
shared
right.
experience.
Exactly, something with the color, and obviously everybody can't come, but that was the main idea between like green, wearing green, did we just get locked in here? Green in
Oh,
September.
you know what? It might be, they might be locking the building down if the lights just went off.
So we'll have some,
Someone's gonna go in.
Yeah, they're here till 10:30.
so the Green Day in September and then ties it into May where there's color and everybody gets to learn something. And there was a DJ last year and we had new level
Nutrition at the end, and they were giving teas and little cupcakes.
They weren't, yeah, they weren't giving.
They
They were
were
like.
in charge.
They were.
That was a conception. We thought there was gonna be donated.
They were not. They were
They were
just,
not.
they spent $55.
Yeah, it was
Between
easy.
Ellen and her friend.
So we did get, the Smithfield Rotary donated a bunch of stuff that day too, so that was good.
Yeah.
So we are looking again for that, companies who want to, partner with us to help us with like the water bottles, and we went through baby wipes insanely because just wanting to get the paint off and stuff, so they, like little things like that, because again, they add up really fast.
We'll do something for you. You should reach out to George too.
Oh.
You know he'll do.
Even, yeah, sponsors, we can always look into sponsors. Signs in the
And
trail.
Building Bridge had a great idea doing wish list.
Yeah.
Yes, we thought about that too, wish list, because we've been, all the craft things, all of the positivity showcases, all of us, three of us just buying stuff, so it adds up. Santa rings.
Oh, so, all right, so Santa is this Saturday. I know there's a million things happening on Saturday. Old County has their bazaar. It happens every single year. The parade is at night also every single year. It is nothing new. We have, we've had the huge turnout every year to Santa. Each year it's gotten bigger. So the event itself is from 9:30 to 12:30, but Santa will only be there from 10 to 12 for pictures. Last year in the 3 hours he overheated. So we tried to open a door up for him, but then everyone else froze. So to kind of, or they were running out into that little courtyard. So to kind of balance that out, he's just gonna do the 10 to 12 because that first half hour there weren't a lot of people, and at the end it was kind of dwindling anyway. So we'll have that. For then we're gonna have pictures, crafts, letters to Santa, and sensory bins like we did last year. The photographer is a parent in town that donates her time. She edits all the pictures professionally. We email them out to all the families. And she's also going to be raffling an 8x10 printout to one of the families that day. The crafts, they range in abilities. Everybody can do them of all abilities, and they can all actually be made into gifts, which is super fun. There's a Grinch plastic ornament ball. You guys may have seen that. It's like a popular thing. A Santa ornament it starts out of popsicle sticks. A snowman that's a magnet. So that's a fun one. And then a stocking that you can kind of like decorate. Letters to Santa. So it says letters to Santa, but just to clarify, it's okay if somebody does not write. They can draw a picture, they can scribble, they can just whatever they want on the paper, or just stick a paper in an envelope. All we need is a parent to write a return address on it. That's the big thing. And then after the event, we bring all the letters to Greenville Post Office, and then they send a letter from Santa to all of the children. Last year we did have some families from out of district. Again, we try to keep it in Smithfield, but we did have some families that came out. And I'm touching on this because Eileen said we just had a family move out of town. Greenville Post Office will still send it out. They won't do it obviously for like the masses, but they will do it here and there. And then we have the sensory bins. They're big bins this year: rice, corn, pasta, kinetic sand, and then a huge fidget bin, because I will find me with a fidget bin all day. And then we're partnered with the Smithfield Rotary, just to give it another element, to give it back to the, give it back to town, for the thing, roping it all together, that we're collecting lightly used winter apparel and new toys unwrapped. We're gonna bring all the things to them after, and then they'll disperse them to the families in need. The setup that day is at 8 AM. Anybody wants to come?
So we weren't able to get in
a lot.
on that Friday.
No. There's just a lot going on everywhere, and with the parade being Saturday, a lot of people are starting the parades up on Friday, but they're opening the doors at 7:30, so I'll be here at 7:30, because last year they told us they were opening the doors at 7:30 and they didn't have them open at 8. So, but everything is pretty much like everything that goes on a table is in a bag together, so it's just like dumping a bag and getting it all out. But then we have to be out by 1 o'clock, so even if anyone's able to come for the breakdown, because we have a half an hour to break it down. Again, because of the parade, people are getting ready. There are 10 to 15 volunteers from the Ability Bridge Foundation that are coming to help. They're going, while they will be there to help set up and break down, they are more there as buddies that day. And probably going to be at the different craft stations just to kind of assist with the crafts going on. So yeah, anybody who wants to help. Let me know.
How many are in the, that seems like a lot, there's more than 15 in the ability.
There's a lot of kids that are going.
There's only like 4 or 5 executive board, but then there's volunteers. Right.
I think you have enough.
Do you have any updates?
So I did update the webpage.
Yes.
And we did test out, so remember, we've always talked about, can we pull like 504 and
Yeah.
IEP, like parents' email address to send out like blasts. So I tested it with the Santa. And so far, it looks like only 4 emails were not working, didn't go through. It looks, it's trying to keep sending it, so then I get a message like, oh, we'll try for 48 hours, or we'll try for 72 hours, and so this morning I got another one that didn't go through, but I thought that was pretty good.
Or on only district, that's huge.
Yeah, so, I felt like that was successful, so that now we'll be able to blast things out, so I was excited about that. And I think, we did have a professional development day.
Which is great.
We went
It was
over.
so good,
Mhm.
right? Like
Thank
we
you.
just telling Jerry Attorney, but we went over every layer of the IEP, so that
That's great.
district-wide, we could be more consistent and really look at the students' needs, and there's a reason why it's called individualized.
Right, that's great. I feel like that's
Yeah,
a
and
great
that's
idea.
how important the parent input is,
Mhm.
especially in the level.
Team member, yeah, that's an awesome,
Yeah,
that's a really good.
so I have to fill out that survey.
What has been the outcome so far from that camp?
From math camp, so it's only been running this
Right.
week, but so I haven't heard anything like negative. I know.
A whole bunch about that whole camp.
I know.
It was Monday.
It was today for Pleasantville.
To today?
Yeah,
Okay.
today was the first day of it. Tomorrow,
Okay.
today and tomorrow.
So I
It
think
all
it's,
depends on what school you're at.
yeah, because I think
I
the
missed
work has two different sessions.
What do you have to read under math?
I wanted to, was available.
Yeah.
Today, tomorrow.
What do I bring out?
I'm gonna choose three tomorrow here, because I'm
Oh.
subbing for some, Get to go Pippin, I wanted to be the sub even.
Oh, you can more than sub, girl.
Pretty much
After today, go right ahead.
Yeah.
I know we saw it.
And then if anyone has any open, any comments, questions, concerns, you have if anyone's awake after the presentation.
I do just have a question for other parents or, I guess parents.
Yeah.
with
I know.
Family members who have kids that are special needs who are into sports or anything like that. I don't know if anybody's aware that Special Olympics has stuff that they do bowling. They used to do basketball. I don't know if they're still doing it. The team that my son's on. I'm saying, there's track and field, and then Smithfield itself has a Challenger Division
Yeah, the little-
baseball team, there's a basketball,
Mhm.
league that, Mr. Swallow has been doing, but I don't know if the word's getting out. Because, we've met other people and we're like, oh, did you not know about this? And they're like, no.
The
no,
basketball-
no, because I wanna try to get my daughter.
Honestly, the basketball is the
Basketball last year.
Yeah, I did.
They were doing the basketball, they don't notify the basketball.
The basketball, honestly, I need to find out, because
No, it's trucks back here.
One of the.
Dragon field.
Fields will be in the spring. Yeah, she's a runner. She's a runner. Go onto the Special Olympics website. Everything's there. You can look them up.
Brian.
Brian, yeah.
State.
Yeah. And the state teams are at your round. And there's different teams. So, and they have on, yeah, young athletes.
Yeah.
Yeah, that's what like. That's why I'm bringing that. Go on to the special Olympics.
Last year when we started up the basketball.
Yeah.
Yeah.
Or basketball. Alright, for the challenger team in town, the only, so. In order for any sports in town, you have to already be part of the organization to get the email. Then for the challenger basketball team, the people that got the email about the registration for that specific team were either on it last year or part of the challenger baseball team. So, yeah, we do, like, we post things as we see them on our page. But again, you know, there's so many posts and Facebook is super busy, so go ahead.
I know last year, cause I was the one who started it up with Jeff. This year I just didn't do it, Grayson just wasn't into it, yeah. So I started basketball because I coached Ella for years and I'm like, all right, now I have to do something for Grayson. So we started, but I sent it to Eileen and she sent it out. So what we could do is we can contact the challenger team and contact these teams and
And then I can,
let Eileen know.
now that I have.
Now that she knows how.
Cause she
Mr.
did
Swallow is
last
the one who did the basketball.
Yeah, I was the one that started with it.
Yeah.
Yeah.
So he's the
But
one who does
when-
the basketball.
That's what I'm saying,
Amanda.
when registration happened, we also.
Let her know if she
Eileen
needs
had
anything
texted
from
if she could
baseball. My
only
husband will take
email
care of
the
it.
Yeah.
team,
Yeah.
like those families, so now we know that she can, so she can.
I can send out a blast.
Baseball, you know.
Yeah.
I'll get
Her
something
husband
over,
was-
whatever you
He's
need.
the president of the baseball, so that would be that'd be perfect. Yes.
Well, the baseball, they do have a challenger division.
Yes.
And that,
But getting the word out
Ralph-
there,
Ralph
Ralph
is the
Woodrow.
one who
Mhm.
sends a blast out.
Yeah, but unless
Well,
Eileen
so-
sees it, she's not gonna.
Yeah,
get that.
yeah.
Yeah.
And I know it's
Any
included
flyers
on-
are helpful. 'cause
I know
can
it's
access
also
it.
included on the, baseball.
The website, Facebook,
Website.
yes.
Yeah. Yeah, so as long, and now that you have the emails working, we can just.
Yeah.
It's so much easier.
Yeah.
Yeah. Perfect. Anybody else for?
Good. I wish my camera
Better.
stop recording without my face in it. Oh my goodness.